This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together. Now we're going to go to our popular question and answer session. So Lauren and I are going to go rapid fire back. And Lauren, we did this for the first time on our first Friday that we did about 2 weeks ago. So we're getting to be pros at this. So we're not going to really transition it. We're just going to do a couple questions. I'll do a couple, then Lauren will scoop right in and finish hers. So the first question is, did you say what a good reserve amount for an HOA to have is on hand? So how much money should we have in our reserve? So the answer to that is get a reserve study. Hire a qualified, licensed professional reserve company to provide you with a reserve report, which will tell you how much money you should have in your reserve. They'll come out to your property, look at your amenities, and it's a very valuable tool. The cost on that's going to be somewhere between $800 and up to maybe $5,000, depending on how large your association is. There's no rule of thumb like $3,000 or 3 times, what your monthly assessment income is. That is not a rule of thumb, and that is not something that your association should ever use to determine how much money you should have in your reserve. And that's kind of a misperception, so I wanted to mention that. Next question. If someone has been given a fine and they ask to see all of the lot files that have a similar type of feature, do you have to allow them to see the lot files and approvals or declines, or is this considered personal information? My answer to that is yes. It's my opinion, you do have to provide that information if the owner requests it about the other owners. And I do not think it's personal information. Personal information would be like somebody's personal cell phone number, home phone number, social security number. But whatever's in their lot file, as long as we're not in litigation with that particular owner, would be fair game for another owner to request. What can an HOA invest in? Just CDs, or can we do stocks and bonds? So my answer on that is you should be doing safe investments. Most associations are only putting money into CDs. I do not know any associations that are playing in the stock market or buying stocks and bonds because they're considered risky. Next question. I believe condo associations spend approximately $80,000 to $90,000 for work done in units. How can we ensure that the board collects all monies for work done in units? It's kind of an unusual question because really condo associations typically are not doing interior work for associations that are condominiums, right? Usually the owners are responsible for the airspace of their units. I don't know if maybe there's been an insurance claim or why there's work being done. Maybe there was some damage that was done by the association. I think you need to really reach out to your trusted advisors to ask this question after getting more facts and details to them. Okay, switch to Lauren.
Okay, so my first question is, when purchasing a house in our HOA, who is responsible for disclosing HOA debts and lawsuits? That's the association, or if you have a management company, your manager. All the financials of the association and any kind of pending lawsuits are to be disclosed in a disclosure statement that you provide when you're contacted by a potential purchaser. So all of that should be disclosed either by the board, or if you have a manager, your management company. Our next question is, what are the guidelines for establishing a working or ad hoc committee? So this is going to depend on your governing documents. Check your bylaws, check your declaration to see what it says about how the board should form committees and how the board can appoint people to serve on that board. Usually the situation is that the board of directors has the authority to basically create and appoint a committee, whether that's an architectural committee or something else. And that the board also generally has the ability to appoint people to serve on that committee. But definitely check your documents because that's not the case for every association. Our next question is, we're a gated community with narrow streets. How can we best enforce our no parking on the street rule? This is unfortunately pretty common. So look at your documents, see what it specifically says about parking, because it may already be addressed in your documents. And if you do have a provision that says no parking on the streets or something like that, obviously send violation letters to homes or to lot owners, homeowners, where you can identify that it's their vehicle that's parked on the street. You may also have the ability to tow a vehicle if it stays there for too long. Definitely double check your CC&Rs. Do not tow a vehicle if you do not have the authority in your CC&Rs. But we still advise you, even if you have the authority, to be careful, because the association incurs liability when you remove a vehicle and you tow it to a towing yard. So keep that in mind. But what you really need to do is make sure that you are fairly enforcing the document, that you really are sending violation letters to everybody who's parking on the street. Make sure you have a uniform front in that regard, and then contact your attorney for further violation or further enforcement action if you don't see that this policy is working. Okay, so another question is, can two board members from the same household serve on the HOA board together? Maybe. We don't advise it because typically people from the same unit tend to vote the same way no matter what, but they can if your governing documents don't permit it. I can't tell you how many people actually think that this is a law and it's not. So double check your bylaws, double check your CC&Rs to see if they have anything prohibiting this. If they don't, they're allowed to serve on the board together.
Okay, next question. For in-person meetings, we require the resident to identify themselves by name and their development in the community before speaking. With the virtual meetings, we've had several people sharing Zoom links, and we don't know who is logging in as they are listing themselves as anonymous. In our email agenda blast, we say members must sign into all Zoom meetings using their proper first and last name. This will allow verification for your participation. Failure to abide by this request will result in the participant being removed from the meeting. Can we kick anyone out of the meeting if they don't comply? We don't call on them, but they are free to comment. We haven't pressed the issue because we were hoping to move to in-person meetings again, but haven't yet. So I guess the question is if you don't know who is dialing into your Zoom meeting, do we have the right to kick them out? I guess my advice on that would be, first, you're doing a lot of the right steps. Have the notice state that, you have to provide your first name and your last name, and maybe even your unit or lot number or your address. And then if they get on, and I have been on a number of Zoom meetings where people are anonymous or it's just a phone number, what you can do is either send them a private message through the messaging system, on Zoom, and ask them to either identify themselves or they'll have to get off the call. Sometimes with the phone, they can't see the messages, so you may have to actually call them out in the meeting and then unmute them so they can say their name, and then just say, if you don't say your name and address or whatever, then you'll be asked to leave the meeting, and then you can just kick them out. So it's definitely, it's a problem that's come up since we've converted to virtual meetings, but it sounds like you're handling it properly. I wouldn't kick them out, though, without first trying to find out who they are. The next question is, what is the best way to handle a condo unit that is over occupancy, 2-bedroom, 2-bath, has 7+ people living in there? The person listed on the resident registration moved out. Our community manager has sent notifications to the manager of the unit with no response. I think the best way to handle this would be to get your attorney involved, and have the attorney contact the owner and find out what's going on. Make the owner aware that the registered resident who he registered or she registered as their tenant doesn't live there anymore, that there's 7 people there, and try to find out more information that way. You do have to be careful on occupancy limits because sometimes, under the Fair Housing Act, there can be that many people that are living there if they're all related. So I think the best way to handle it would be to have your manager or your attorney reach out to the landlord owner and make them aware of what's going on, and require them to fill out a new registration form. If there's new people that are living there, you are allowed to do that. We have a cheat sheet on rentals that has the information that we can request from a landlord. I'd encourage you to take a look at that. Next question. Bylaws state the annual meeting must be held in November. We have held ours in February for years. Are we in trouble? So the short answer is probably not, if you haven't been sued for this yet. And it would be, kind of a flimsy lawsuit, because there really aren't any damages for that. But I have seen lawsuits of that nature. So what I recommend going forward is that do it properly. So have your annual meeting in 2021 in November. Going forward, if you already had it in 2021 in February, which may be the case, then what you'll want to do is consider either amending your documents, so the bylaws, so that you can have it in February every year going forward. That may require a vote of the membership, likely it will. Or what you can do is when you go to 2022, in February, make sure you're communicating to the owners that, hey, we're having it in the wrong month in 2022. We're actually going to have it in November pursuant to our bylaws. The next question is it common for association boards to have the same board member act as the president and treasurer? If so, is this a widely held practice? So short answer, no, this is not common. It's not a widely held practice. Why? Because both jobs require a lot of work. Being the president is an enormous amount of work. Being the treasurer is not as much work as president, but you really have a lot of responsibilities overseeing the finances of your association. So it's not recommended, of course, that these two positions be held by one person. And there really do need to be checks and balances in place between the two positions. So I'm going to switch to Lauren.
Okay, so the next question is, if your neighborhood has not had an architectural committee in years, is the president allowed to just approve or deny claims as he or she wishes? Check your association docs to see if you are, one, required to have an architectural committee, or if you don't have a committee, if the board is allowed to act in the architectural committee's stead. Definitely check to see what your language says. In our opinion, one member of the board of directors should not be making these decisions on their own. So if you aren't required to have an architectural committee, and if the board can make those decisions, we recommend that the board actually make those decisions and not just one board member. The next question is, if a special assessment was passed and collected for a capital improvement project to add a front entrance security gate, and the project estimates are $125,000 over what was projected, can the board use funds from the reserve account to cover the difference? So first, check your reserve study documents and just to see if basically where that money is allocated that's in your reserve fund. Is it going to be used very soon to, repave your tennis courts or something like that? Because if so, you may not want to take that money out. So definitely check it and see if you do actually have money that could be available for use. This probably can be done, but you just want to double check to see what your reserve study says and also what your declaration says. Sometimes your declaration is very specific about what the reserve funds are going to be used for. Okay, the next question is, when a board makes exceptions, such as a patio extension or a variance to landscaping in areas, and especially by a wall that's at the rear of an owner's villa where nothing has grown in years, can an addendum to the CC&Rs be added to cover those exceptions? So we'd have to have more details on the situation and what has or hasn't been approved to really truly weigh in on this question. But the short answer is that if you want to amend the CC&Rs, you have to have a vote of the membership to do so. So the board can't pass an addendum on their own. You would have to basically amend the CC&Rs with membership approval, or potentially amend the plat or the CC&R, or I'm sorry, amend the plat if you've potentially given away common area land or something of that nature. Okay. Our next question, how do we handle a rotating door of property managers? You generally get a new manager every year. This means about 9 months of actual work, and the rest is coming up to speed or slowing down, knowing that they are leaving. And some managers have too many properties and you get pushed aside because you're a smaller community. So what you should do is you should communicate with the president of your management association. You want to talk to them and let them know that this is an issue, that you're experiencing this every year and that it's causing problems in your community. Make sure that they understand what's going on. That way the president can make sure that you do have a consistent manager. When you have a manager that you like, make sure you tell the president so that they will stay with you. Make sure that you are voicing your concerns to the president. They're much more likely, in order to keep your business, they're much more likely to try to make sure you have a consistent manager. If this continues to be a problem, even after you've talked to the president of the company, make sure, you may want to consider changing management companies, because maybe they're just not meeting your needs that they should. Okay, I'm going to kick it over to Beth.
Would $1 million loss in a public restaurant in our community during COVID require due diligence by the board of directors? Their decisions resulted in this loss. It's really hard to comment on this without knowing all the facts surrounding, the money that they lost or allegedly lost. I think that your board should, give a report to the community as to, what the losses were due to COVID. Maybe the restaurant, obviously the restaurants, many of them had to be closed. And we're hearing the same fact pattern from a number of other associations. So I don't necessarily think it's, a bygone conclusion that the board acted inappropriately. I guess the most important things are, did the board act in a timely manner? Did they make the best decisions for the community? And let's face it, this was the first time we've lived through a pandemic. And, we had to make tough choices. And sometimes there were mistakes that may have been made. But playing Monday morning quarterback now is kind of unfair, really, to the board. So I would have to hear more information. And do I think that the board's going to be sued for something like this? No, I don't. I think that there's going to be a wide level of latitude to board decisions during this time. Next question. What can you do if the president refuses to provide board packet and won't give minutes to review beforehand, and gives a generic agenda that does not enable to know what will be discussed in the meeting short of a lawsuit? So I don't know if this person asking is a board member, but if you are a board member, you should be given a board packet in advance of the meeting, and that board packet should include the meeting minutes. If you're a homeowner, it's not customary that you get a copy of the board packet or the meeting minutes before the meeting, just so you know that. The generic agenda, really the board should strive to give a detailed agenda so that owners can see what's going to be discussed and determine whether or not they want to attend the meeting. So my recommendations would be that, if this is happening in your community, that the president should be giving a board packet. It's not necessarily the president's job. I mean, you have a management company, maybe the management company is doing it, or maybe board members help the president. And the minutes and the board packet should be given to all board members before the meeting, and the agenda should be detailed enough so that everybody can understand what the topics are that are going to be discussed. Next question. If a homeowner purchases trees or shrubs on their own dime and specifically asks the board not to trim them during annual maintenance, but the landscape company either drastically trims the shrub or they remove trees without notifying the homeowner, does the homeowner have any legal recourse to recoup the expense of the purchase? So we see this sometimes where homeowners gratuitously, add trees or shrubs. I don't know if you're doing this on the common areas or if you're doing this on your property. Really, if you ever do that, the best, advice I would say is make sure you have everything in writing in terms of who's going to maintain it, how it will be maintained, etc. So after the fact, after it appears that the association's landscaping company has responsibility to maintain this landscaping, unless they're given specific instructions, which frankly, it's going to be hard because they have a lot of lots that they maintain. You see things like this happen. So, I think spelling it out early in the relationship, if the board is going to allow something like this, making sure that it's very clear what everybody's rights and responsibilities will be is helpful. But it's always kind of a sticky wicket when homeowners add things like this because they do think that they have special rights with regard to those items that were added. And the practical reality is it's really hard to keep track of maintaining it. It really should just be maintained like everything else in the community is maintained. So if I were advising the board, I would say, it's fine if they want to donate it, but we still have the rights over how it's maintained. And if it dies, of course, it would be nice if there was some sort of an agreement on that before, but more likely than not, there won't be an agreement. What I would recommend to the board is that they just replace like with like. How is it different if the association doesn't charge fees or handle funds? So I'm not sure if that's related to the last question, but I honestly don't understand the question. I'm wondering if maybe they're talking about an association that doesn't charge or doesn't have an assessment or doesn't have money. It's basically just like a voluntary association with CC&Rs, maybe that run with the land. I'd have to look at how your association's set up to give you more advice on that. Our HOA has a restaurant operated under 502c4. Is there a definitive way to know if our restaurant is an amenity or a business? Does advertising to outside patrons make it a business? That'd be a good question for your CPA for the association. They probably would have a better answer than I would on that. So I would direct you to them. I mean, it's probably going to be considered an amenity if it's on your property and is, identified in your documents as something that is, provided to residents and maybe even to non-residents. So it might even be incorporated as part of your the corporate charter for your association. So hard for me to answer that without knowing more. I'm going to switch it over to Lauren.
Okay, so our next question is, can an HOA place a lien for unpaid fines from violations, or are liens only for unpaid dues? Under state law, you cannot include any fines or legal fees or administrative costs related to fines under a lien. Liens can only include unpaid assessments, late fees for those unpaid assessments, administrative costs associated with those unpaid assessments, and legal fees and costs related to the collection of those unpaid assessments. So short answer, no. Next question, should all board members be listed on the Corporation Commission report? Our manager said that you only need to list two, one officer and one board member. I thought it should show all, and it said that the manager signed electronically as the president. We would recommend naming everybody, though, you're supposed to name all of the current board members and the offices that they serve in. Don't get me wrong, you're not penalized for not naming everybody, but we would recommend that you do, since that's what the Corporation Commission asks for. And in regards to manager signing the report electronically, if that manager had the permission of the board president to sign, because usually your manager is tasked with the responsibility of filing your annual report, then that's fine. You want to make sure that they do have the authority to basically sign on the president's behalf. Okay, so the next question is, I always hear that voting, making decisions, or having discussions over email should not take place over email, and that no discussion should take place as well. What would you say to a management company that states they think this is too restrictive, especially since email is so pervasive in everyday life? In their opinion, it's not practical to proceed in that manner. They also indicate that voting or making decisions via email is not found in the Condo Act or Planned Communities Act, but is found in the Nonprofit Corporation Act and is therefore applicable to most associations. So this is tricky. I'm just going to let you know right up front. So the way that the open meeting law for the Condo Act and the Planned Communities Act is written is that any time that a quorum of the board get together to discuss association business or make a decision, it needs to be done at an open meeting that homeowners can attend. So it has to be a properly noticed meeting. So in that regard, no, we do not recommend that you make decisions via email. We do not recommend that you hold a discussion regarding association business via email. That being said, we do certainly recognize that the way that the open meeting law is written is not reflective of the way that the business is done normally. We do recognize that. And obviously your manager recognizes that too. However, in order to make sure that we stay on the right side of the law, in order to make sure that homeowners have the ability to be present when the board is making decisions or discussing association matters, we need to make these decisions at an open meeting. Just remember what I said earlier. Arizona law really does favor transparency in associations. They want you to make decisions where the homeowners have the opportunity to be present. So make sure that you're considering that. That being said, that doesn't mean you can't use email at all. Again, the way that the open meeting law works is that a quorum of the board, it triggers an open meeting. So if less than a quorum of the board are discussing something, that's fine. And obviously less than a quorum can't make a decision or pass a motion on behalf of the board. So that's an option. Something else you can do too is if you need to consider something before a meeting, send it to the board members, but use a disclaimer on your email. Say, we're not going to get into a discussion on this, or we're not going to discuss the merits of this until the open board meeting. I'm just sending this to you for your information ahead of time. So include that disclaimer. In regards to the Condo Act and the Nonprofit Corporations Act, the Nonprofit Corporations Act does say that people can make like unanimous written decision via email. However, there have been multiple decisions by administrative law judges here in Arizona that say that even unanimous written consent via email is a violation of the open meeting law. So our recommendation is always to err on the side of the caution. If a quorum of the board are going to be discussing something or making a decision, you need to do it in an open meeting. I know it's not easy, but that's the way the law is written. Okay, so our next question is, our board always closes the organizational meeting that's held just after the annual meeting and election of new directors to select officers and appoint committee chairs. Is that correct? They call this a special meeting. Yeah, that's fine. This is actually very common for people to hold these these organizational meetings directly after the annual meeting. You just want to make sure it's noticed. Okay, I'm going to kick it over to Beth.
Next question. Can a single board member call a town hall meeting if the majority of the board is not being transparent, so that we can get input and give information on our concerns to the community as a whole, perhaps with guest speakers on some of the topics affecting the association, such as the amendments to the CC&Rs? So really, you need to check what your bylaws state. How to call a special meeting of your board or a special meeting of your membership will be listed in your bylaws. Typically, it's not a single board member unless it's the president. The president would have the authority to do that in most documents. But what I would recommend is that the one board member, go to the board and ask to have this done. If they refuse, then, maybe the single board member could have an informal meeting that they host. It just wouldn't be considered a formal meeting of the board or the membership. But really just try to get along, because some of these boards, when you have factions on the board where it's kind of like reliving middle school, right? It's like the popular group, the unpopular group, whatever. It really creates a lot of unrest and dissension within your communities. So it really serves everybody to be good communicators, along the lines of what Lauren said about transparency and communicating well with your membership. If people are really feeling the need, and maybe it's not just the one board member that's asking for it, maybe it's the community also is asking for that. So maybe the one board member needs to reach out to others in the community and say, hey, can you ask for this too? Then I would say the board really should respect the wishes of the community and have, a town hall meeting to get input on different things. I think that's a great idea. The better they communicate, the fewer the problems you have. Next question. Please confirm your firm's comment during this seminar that boards are required by Arizona law to allow homeowners to speak on each issue the board considers at a board meeting. So great clarification question. Remember, anytime the board takes formal action on something, so anytime the board's voting, so anytime there's the motion and a second, and then you're going into the board voting next, during the discussion period, an owner is allowed to comment, and you could just have to have a reasonable number of people on each sides of the issue, and you can place a time restriction on it. So I hope that clarifies your question.
So our next question is, how do you avoid a town hall meeting from becoming a board meeting? Do you avoid quorum? Do you avoid making decisions? Yes, basically. Yeah, a board meeting is where the board is basically discussing association business and they're making decisions on matters going forward. In order to avoid this from becoming a board meeting, don't make decisions. Just let the homeowners ask you questions and then the board can answer. Just don't take any formal action, and it stays kind of a member meeting in that regard. Okay, so our next question, what can a board member do if the president has their own clique on the board and won't allow certain members to serve in any capacity other than member at large? Can the board member welcome people on their own when they are not being allowed to be part of the team? So remember that the appointment of board members to offices has to be basically on a majority vote of the board. So unless your governing documents specifically give your president the authority to decide what position everybody will serve in, that needs to be a vote of the board. So make sure that that's happening first. If a majority of the board decides, yes, you're going to be the member at large, then that's the position you're going to serve in. You can always advocate to be in a different position or be moved around. That doesn't just have to happen once a year. But if it's a majority vote, then yes, that's the position you're going to serve in. In regards to, can a board member welcome people on their own? Certainly, you can go around and welcome people to the community. If you're not doing it on behalf of the board of directors, just make sure that you're not giving indication that you are welcoming them on behalf of the board. You just want to make sure that you are welcoming them as an individual to the community. But I'm sure that anybody would love that. Okay, I'm going to kick it over to Beth.
Okay, great. The next question is, can a board member share approved minutes if the clique refuses to publish them after they've been voted on in an open meeting? Okay, so this is kind of a slippery slope. So I want to just talk a little bit about this for a second. As a board member, you want to be careful that you're not responding to owners in the official capacity of the board as an individual. So like sometimes what I kind of feel like's happening here is that the board member is feeling like the board isn't providing information to owners, maybe that's requesting them. And they're talking about a clique, maybe they're in the non-clique. And they want to know, hey, can I give it to them if they've already been voted on at an open board meeting and approved? You know, my feeling on this is it's not a good idea for one board member to be responding to records requests that really need to go to the entire board. So I don't think it's a good idea for one board member to do this. What I would do is tell whoever's requesting for the minutes and make sure that it's only the open session minutes would be entitled to be reviewed by members. Tell them to contact the board or the management company to make a written records request. If they don't provide the records within 10 business days, which, you know, they're required to provide the records to owners within 10 business days, then the board member should intervene and say, why has this not happened yet? But going around the board or going around the management company and just having the board member quickly pass the documents that are requested, well, it may seem like, oh, it's no big deal because they've already been approved and I have them right at my fingertips. It really is not appropriate, and I would advise against doing that. Next question, tips for best sources for boards to ensure we're following legal statutes. Simple example, we understand a new owner needs to honor a prior lease from the previous owner, correct? Okay, so what would be some best sources for boards to make sure you're following legal statutes? So if it's any legal statutes that pertain to HOAs and condominiums, truly, our website, mulcahylawfirm.com, has a wealth of free information. Our cheat sheets tab, our resources section, our video library with over 60 videos. We have basically any answer or the answer to any question that you may have pertaining to associations right there on our free website. So I would say go there first for questions pertaining to HOAs and condominium law. Now, if you want to know about landlord-tenant law and you're asking me for the best, place to go, you may want to go to like the state authority. So maybe the Arizona Department of Real Estate to help you with that. Next question, do you have a library of member survey questions that are effective and safe to use? So I'm assuming that you're wanting to do a survey in your community and you want some sample survey questions. I don't have that. I'm sorry. That's one thing I don't have. But there is an art to how you handle surveys and survey questions. So you may want to reach out to your management company or your legal counsel, your lawyer, to help you put together those survey questions so that you get the information that's going to help you make good decisions for your community. Next question, can the HOA board require details of violations? Currently, they're so short, it isn't clear why the violation was given. So I don't know if this person is asking as a board member and they want their management company to provide more details when they're giving like the violation summary report, which absolutely, yes, the management company works for you and you can ask for that as a board, more information. Some management companies even take photographs of the violations and provide those to the board and to the homeowner. Maybe you are a homeowner asking if you can have more detail on your violation. And so of course, you're welcome to request that. There's actually a law that allows you to make that request by certified mail, and then the association has to respond with detailed information regarding the violation, what section in the CC&Rs have been violated, and who witnessed the violation. So I hope that's helpful to answer that question. Next question before we go to Lauren: how can you enforce parking issues when community streets are city owned? If they say that's not my car, how can you prove it is? So it's really kind of a sticky wicket in terms of streets are city or county or town owned by the town or city municipality. Here's how it works. So the association has a contract with the owner and the association, right? And the owner and their guests are required to be bound by the CC&Rs, right? And the owner is responsible for the behavior of their guests. So if you can prove through photographs or documentation from the neighbors that that car, that vehicle belongs to that lot or that unit, and they're parking in violation of the documents on the street, and even if the street is owned by the city, if the CC&Rs say that the owner or their guests have to park in a certain manner within the community, that is enforceable. We don't have any case law in Arizona on this, but there's a really good case out of Missouri that directly addresses this same issue, and we've used it before to defend in lawsuits. And so how do you prove it? Make sure that whoever's complaining about this, whether it's a neighbor, is documenting whose vehicle it is with actual proof. Sometimes we run license plates for boards. There's a charge to do that to help us determine who the vehicle belongs to. Sometimes the company that comes through at night to look for parking violations, they're documenting the information. So just document the information on this. I'm going to switch over to Lauren now.
Okay, so our next question is there a violation of the open meeting law if you send a draft of minutes to the board for review prior to sending minutes out to all of the members? No, it's not, just so long as the board makes a decision to approve the minutes at an open meeting. We actually recommend that you send a board packet to every board member prior to a meeting so that a board member is able to look at the information and prepare themselves. They're not looking at everything for the very first time. So it is fine to send a draft of the minutes to the board ahead of time. They just need to approve the minutes at an open meeting. Okay, so the next question: what is the Arizona state law on collecting fines for violations? Do they close automatically after a period of time, even if not collected? So the association has the ability to collect fines from homeowners. The Arizona law states as such. And you remember that violations are also a breach of contract, because the declaration is the contract between the homeowners and the association. So if you have a homeowner that has accrued a large amount of fines and maybe the violation is ongoing still, the board may want to consider moving forward with an injunctive relief lawsuit where we are asking the court to basically state, hey, homeowner, you can no longer violate the CC&Rs, and you need to pay the association for the fines that have been levied for this violation. That's definitely, I think, the best way to collect fines. We obviously can always ask the homeowner to pay the fines, but I'm going to let you in a little secret. Homeowners are very aware that when associations don't collect fines, that the association isn't losing money. So it can be kind of an uphill battle, and we just need to keep in mind, is it worth continuing to pursue? Is it worth spending money on? Is there a violation that's still ongoing? That's the big question. We need to remember that the purpose of these fines are to try to get the owner to comply with the CC&Rs. And so we need to think about, if compliance is achieved, the board could potentially waive the fines or leave them on the account and see if the homeowner pays them. But they do not automatically disappear from the account after any kind of period of time. Unless the board decides to waive them, or if the homeowner sells the property, then the new owner is not responsible for the fines. Okay, so the next question: as a homeowners association, do we have the right to say we don't want somebody to buy a home in our community after having experience with that person as a renter in our community? No. you really don't have a say on who lives in your community unless you happen to be a 55 and older community. And the people who are trying to buy a home are all under 55. Or not, well, let me take that back. They can buy a home if they're under 55. We just need somebody who is 55 or older to occupy the home. But no, you really can't have any say in who lives in your community or not. So yeah, I'm going to kick it over to Beth now.
Okay, great. Next question. Our HOA board is doing architectural reviews and voting by email. They are holding long dialogues by email and voting. I have recommended that they notice the architectural review meeting a week prior to the regular board meeting so homeowners can attend via Zoom or in person for architectural review. They're also discussing everything from regular meeting and executive session. Okay, a couple thoughts on this question. So it appears that you think your board is making decisions on architectural requests by email, and also that they're talking about regular meeting topics in executive session. You want to be careful because you want to make sure that you actually have knowledge that your board is violating the law. And so our recommendation, of course, is that the board should make every effort to have their architectural reviews. What kind of from a practical standpoint, why aren't they just doing it at the regular board meeting? Just make a section of the regular board meeting the discussion of this. That would make things really easy. Or maybe have a separate architectural meeting if you have a lot of them. I do know that during the pandemic, it's undeniable that a lot of architectural committees have been making decisions by email. I think it's just important to remember, that regularly scheduled committee meetings are required under Arizona law to be open board meetings. And so I don't know if your architectural committee regularly meets or if you just meet sporadically. Maybe the open meeting law doesn't even apply to you. I do know that at least one board member has to chair the architectural committee. So just some things to think about there. If your board is acting as the architectural committee, it would just make sense to me to have the discussion and vote on architectural requests just be a part of the regular board meeting. Remember, executive session is only for executive session topics. So really the most common reasons for board to go into executive session are to get advice from their attorney, delinquencies, violations, maybe matters pertaining to employee issues with the association or matters pertaining to independent contractor issues, problems. So just a refresher on that for your board would be helpful. Next question, we are a small HOA with no restrictions on renting homes. Rentals are increasing. What steps are permissible to limit future growth of rental properties? You may want to look at our cheat sheet. We have 2 cheat sheets that I think would be really helpful to you, and they're on our webpage, mulcahylawfirm.com. Just click on the cheat sheet tab. One is on rental properties, and then one is on amending CC&Rs. And the flip side of that one is implementing short-term rental restrictions. So I think you definitely need to reach out to your legal counsel to discuss what your options are. You may want to consider amending your documents, your CC&Rs to limit rentals. I don't know if you're a condo or a planned community. It's much more difficult to do that if you are a condo. There are some provisions in the Condominium Act that make it pretty impossible to, eliminate rentals. The Planned Communities Act is significantly easier. So reach out to your trusted advisors, your legal counsel, to talk about what would be a strategy if you want to limit the future growth. I'm not ever in favor of putting like a cap, like a 10% cap or 20% cap on the number of rentals that can be allowed in your community, just because it's a nightmare to enforce. It basically makes the provision unenforceable, because how do you decide who's going to be in that percentage? So if you're thinking about doing that, just know that I don't think that's a good idea. So I hope I've given you some tips. Look at our cheat sheets, reach out to your legal counsel to talk about some other suggestions on how you might be able to limit rentals going forward. Next question, we have a board member who runs a daycare from her home. Our CC&Rs state that you cannot run a business from your home. The board member advertises her daycare on the community's social media page and has photos of multiple children using our common areas. Does this put our HOA at risk of a lawsuit? Well, in the pandemic, things really kind of have gotten a little crazy in terms of working from home, right? I had a question yesterday where we had a parent homeschooling her children, and the community's board was claiming that that was running a business, which, I mean, come on, all of us who have kids have had to homeschool, and many of us have been working from home due to the pandemic. So I think we really need to look at what's going on here. Is this like a licensed daycare? Is she watching her grandchildren? I mean, I would ask for more information. I'd get your legal counsel involved to weigh in on this. I'd like to see the specific language that's written in your documents. I'd like to know if the person is registered as a daycare with the state of Arizona. What does your city, town, municipality ordinance say on this? All of these things are important. And without knowing that information, I can't tell you whether or not this is going to put your association at risk of a lawsuit. But it is something that you should definitely start asking some questions on, would be my recommendation. Next question. We recently had a resident pass away in front of our clubhouse. Oh, I'm sorry to hear that. While there is an AED present inside, no one used it. When staff was asked, they stated that either they used to be certified, and since they aren't currently certified in CPR AED, they were uncomfortable using the AED, and a couple of them stated they didn't even know how to use it. My question as a new board member is twofold. Can we mandate that our management company add annual CPR AED training for their staff? And if not mandate, can we ask for volunteers to be certified or recertified? Okay, so yes, I think it's a good idea for you to have anybody who's on the ground and is, like an employee of the association or independent contractor for the association within reason to get this certification. So if you have a clubhouse, it sounds like you do, anyone who's currently working inside the clubhouse, maybe have an annual certification that's mandatory for all the employees in your association. I think that's a great idea. If they aren't certified, the follow-up question was, what is the liability if they used it and, maybe somebody got injured because of their actions? I think there could be some liability for that. It would likely be covered under the association insurance policy, but it's a situation we never want to be in. So, obviously, just because somebody's certified or trained doesn't mean that they may use the equipment right in the stress of the moment. You'd have to look at the facts on a case-by-case basis. Did they act reasonably? But again, there likely would be insurance coverage if something, went wrong on this. Is there some sort of a Good Samaritan law that covers the use? I want the board to enact an emergency management plan for the clubhouse and pools. And we are also working on a CPR AED training drive in the community as a result of this event. I don't know if there is a Good Samaritan law. I truly, that kind of exceeds the scope of, this call. But I'm pretty sure that if you Google that, you should be able to determine an answer to that pretty easily. My feeling is there probably is some sort of a law that if somebody steps in to help, and they acted in a reasonable manner, that, there wouldn't be liability. But like I said, I don't know the exact answer on that. So you need to do a little follow-up on that. Next question. Our landscaper is neither licensed or bonded and is $8,600 more per year than our next bid. However, our president wishes to not switch landscaping companies. Okay, so I'm assuming you want me to weigh in on that. Most landscaping companies, do need to be licensed, especially if they're doing any sort of irrigation work. So I think it's unusual that your landscaper isn't licensed or bonded. I don't know if they're carrying insurance, but all three of those are check, things I think your landscaper should have. And the fact that you're paying more raises some concerns too. So what I would say is, just on the record, I think that you need to raise these concerns, say that you attended a seminar where this was discussed, and it's, best practices to have licensed, bonded, and insured contractor, and that we should be bidding out a contract such as a landscaping contract at least every 4 years. Next question. CCNRs say we can have up to 7 board members as long as it's an uneven amount. Our HOA attorney answered in an annual meeting that we would need a vote from the homeowners to increase our board from 3 to 5 to 7, or to 7. However, in our last meeting, the management company said the attorney was incorrect, and there's nothing we can do if the actual HOA chooses to not change. Can you please clarify which is correct? So usually the number of board members is listed in the bylaws. So I would check the bylaws, I check the articles of incorporation, and I check the CC&Rs if I were your attorney. And I would, determine what the documents say on the number of board members. The CC&Rs are the highest document they're going to control. So if they say you can have up to 7 board members, usually we'll also say like the board can increase or decrease the number of directors. So I don't know, maybe that's what your document says. So without seeing the actual language, it's really difficult to comment on that. My experience tells me that usually the board decides how many board members there are. And usually that's something that's listed in the bylaws and the articles of incorporation, not usually in the CC&Rs, but every association has different documents. And the next question, we just have a few more and we're kind of running right out of time. So we're in a good spot. We recently had a public event that several board members attended on their own. Because one of the board members was a member of the group sponsoring the event, she was asked to say a few words. Of course, someone got offended because someone was left out of the acknowledgments for the event, and various residents have complained to the board that they want the board member who spoke to be sanctioned. Since this wasn't a board event and we had no prior knowledge or approval of the remarks, we feel this isn't a board issue. Well, that said, my question is, would it be advisable to have the board to purchase golf shirts with our logo? And if we're representing the community in public, like meetings, et cetera, we wear the shirt. And if there's no board shirt worn, then the person is representing themselves. Here's what I recommend. I recommend that anytime a board is talking in their individual capacity, they say, I'm here in my individual capacity. If you're there as a board member speaking on behalf of the board, say that's how you're speaking. I don't really think it's necessary to have shirts. But recognize if you're representing the board at some event, whatever it is, you need to have the support of a majority of the board for any comments that you say. Okay, I'm going to switch it over to Lauren.
Okay, so our next question is, can our annual meeting encompass a regular monthly meeting, i.e. combine the two? We generally don't recommend this. What you can do, this would be a long day, but you could hold an annual meeting and your monthly board meeting on the same day, maybe back to back. That's totally fine. You'd have to make sure that you have the proper notice for each, because the notice required for a member meeting is different than the notice required for a board meeting. You could do it, but we do generally recommend that they're separate. You absolutely can't combine the board meeting and the annual meeting into one meeting, because your annual meeting is a member meeting where the board gets elected. It's a homeowner meeting, and board meetings are kind of the general operation of the community in the board making decisions. So they do need to be separate, but they can be held on the same day if you would like to do that. Okay, our next question, is it true that the only unpaid assessment that can result in a lien on the member's property is for unpaid dues? I believe what you're asking is it true that liens can really only be for unpaid assessments and the fees associated with the unpaid assessments? Yes, that is true. We can't include fines. We can't include maintenance costs if you're allowed to, maintain an owner's property if they fail to maintain it. It really just needs to be for unpaid assessments. It can be annual assessments, special assessments, things like that. But you do need to make sure that it's just the unpaid assessments, late fees for those assessments, the collection costs or administrative costs, and then attorney's fees and costs associated with those assessments. Those are secured under the association's lien. Okay, our next question. Is it legal for an HOA president to have a family member's company as a vendor for referrals? An example is the HOA president refers homeowners who are required to paint their house to her son's company. Also, is it legal for that board member to receive kickbacks for referrals? So it is legal for a board member to refer, say, hey, you could use my son's painting company or something like that. It definitely does raise a question of maybe a conflict of interest. Keep in mind, though, that both the Planned Communities Act and the Condominium Act state that the only time a board member really has to announce a conflict of interest to homeowners is if the board is considering hiring or paying money to somebody in the in the board member's family or the board member themselves. So if they were thinking of potentially hiring the board president's son's company to paint all the homes in the community, the board member needs to stand up at an open meeting, say, I just want everyone to know, full disclosure, this is my son's company. So association funds would be going to pay my son to paint homes in the community. And then the board member is actually still allowed to vote on the motion. So they just have to make that known. In this case, we think that they probably should disclose, hey, this is my son's company, and probably give other options. Hey, here's some other options for you, other companies that we think are fine. The board member shouldn't be receiving kickbacks for giving any kind of referrals. Board members are always supposed to work without any kind of compensation. So they should not be getting any kickbacks. Okay, our next question. Can the board require a board member to submit their requested amendments to the minutes prior to the meeting? Wouldn't this constitute a discussion outside an open meeting? Not necessarily. So you could send out meeting minutes ahead of the meeting, and you can say, if anybody has any amendments to the minutes that they want to present, email them directly to me. Don't include the other board members. So again, if it's less than a quorum of the board, you can do that. So a board member could email you back directly and say, hey, I don't think this is how the discussion unfolded. I think you need to make this amendment. But we generally recommend that board members actually do this at the meeting, because you're approving the minutes at the meeting. So we recommend that you do it there, but as long as it's a direct email where you're not opening up a discussion, it's fine. Okay, so our last question. Am I able to run for the board if I am also in litigation with the association? This is a really good question, and I've actually run into this recently. Yes, you are. You are allowed to run for the board, but be aware that you are absolutely not privy to any board discussions regarding the litigation. They can ask you to leave the room, and you should. They have a right to discuss the association's defense in the litigation without you as the plaintiff being present.
Thanks for being here today. We really appreciate you attending, caring about your communities, wanting to make your communities better. I'd just like to thank our partners for the 2021 Virtual HOA Condo Academy, the neighborhood services from all over Arizona, which are the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, and Tempe. Our firm really appreciates partnering with you to provide free education to board members, homeowners, and managers. We would love to have all of you join us again for our next Virtual HOA Academy, Condo Academy, on Tuesday, May 18th at 11 a.m. It's class number 5 in our series of classes. We're going to be talking all about vendors, hiring, firing, and everything in between. Because a lot of the questions today talked about vendors and whether they need to be licensed and how to work with them effectively. We're going to cover all that. Plus, we're going to talk about how to negotiate a contract with vendors, including your management company, landscaping company, really big projects, how to negotiate those contracts, the importance of using licensed and bonded contractors, how do you handle disputes, performance issues with your vendors, including management companies, how to end your relationship with them and come out as a win-win, and then how to find a new company if you're in the market for a new vendor, management company, landscaper, whatever you're looking for. Finally, like always, we're going to have a Q&A session at the end of the class, so make sure you bring all your questions. Hope everybody has a great month. Thanks for joining us here today. Lauren, you did a great job. Thank you for being here. And we'll look forward to seeing you guys in May. Take care, everybody.